Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. I thought I was in a good place as I got behind my microphone on Saturday morning to record these cases. But having just recorded them, this week is complicated, everybody. Lots and lots of crimmigration and lots of important issues addressed in almost every decision. Maybe I'm losing a step. Unlikely. 7 of them. I hope you brought your thinking caps. Of course, I'd be remiss not to note that Judge Hannon has again deemed DACA illegal. I guess. I have not read the decision. As I understand it, though, current DACA holders retain their status. DACA remains in flux still, forever. Here's what the other court said this week. Our first case is Hermosillo v. Garland, published by the Ninth Circuit on September 14th, 2023. This case is about reasonable fear interviews. Judge Bennett dissented. Mr. Hermosillo is from Mexico. Long story short, he was physically removed following an expedited order of removal in 1999, and then he re-entered the United States without authorization afterwards. When caught, DHS reinstated that final order of removal, and Mr. Hermosillo did pretty much the only thing that he could. He claimed to have a fear of return to Mexico. That got him an interview with an asylum officer to see if his fear was reasonable such that he could be placed in withholding-only proceedings before an immigration judge. Quote, non-citizens show a reasonable fear of persecution if they establish a reasonable possibility that they would be persecuted on account of a protected ground, end quote. Same with torture, only a reasonable possibility of torture. This isn't the full-fledged adjudication of the fear. That's what withholding-only proceedings are for, following reinstatement. To be uber clear, quote, a reasonable possibility requires a non-citizen to show at least a 10% chance of being persecuted or tortured, end quote. An asylum officer said that Mr. Hermosillo didn't meet this. Credible, but not met. All while in immigration prison without bond and therefore a limited ability to get supporting documents in this expedited fear screening process that we have. Mr. Hermosillo credibly testified that he feared the cartels in his hometown. Quote, Autodefensa, a local community defense group, fights to prevent cartel influence. As part of the conflict, the cartels carry out weekly attacks to kill Autodefensa members, end quote. Mr. Hermosillo was not part of Autodefensa in Mexico, but his uncle was a leader, as was his father and other uncles. All of them have been murdered. Very brutally, too. And as Mr. Hermosillo testified credibly, the cartels target the family members to instill fear and stop all resistance in the community. Family members like him, Mr. Hermosillo. He's not 100% which cartels, however, killed his family. He believes the cartels will learn about him if and when he's returned to Mexico, and that the police are in cahoots with the cartels. See, for example, recent reports discussing the reasons for those missing students from a few years ago in Mexico. Again, though, insufficient, said the asylum officer, to establish a reasonable fear of persecution or torture. No nexus to a protected ground, and no showing of police acquiescence for cat protection, said the asylum officer. The uncles were killed, the asylum officer believed, because of their involvement in autodefensa, something that Mr. Hermosillo was not involved in. An immigration judge reviewing the asylum officer in a pseudo-appellate capacity agreed, no reasonable fear. That permits petition for review to the Ninth Circuit, bypassing the BIA, and in no small part because of the Ninth Circuit's recent decision reiterating its jurisdiction just last week in Alonso Juarez. And on petition for review, the Ninth Circuit sent it back. Because see, said the Ninth Circuit, quote, Mr. Hermosillo credibly testified that the cartels launch weekly attacks against autodefensa members, end quote. Death on account of family membership often satisfies the withholding of removal nexus standard. And these are simply reasonable fear interviews. Quote, non-citizens in expedited removal proceedings cannot realistically be expected to produce for the asylum officer's review the kind of detailed country condition evidence that would be introduced during a merits hearing before an immigration judge, end quote. Like expert testimony, not expected at the reasonable fear interview stage in the Ninth Circuit. Therefore, and here's your big holding for the week, quote, a non-citizen's own statements can supply adequate support for claims about country conditions, at least for purposes of satisfying the 10% threshold necessary to pass a reasonable fear screening interview, end quote. The asylum officer and the immigration judge not only appear to have held Mr. Hermosillo to an overly burdensome standard, but they neglected to consider that the uncle's murderers might have had mixed motives. Those uncles might have been murdered for family reasons, too, reasoned the Ninth Circuit. That Mr. Hermosillo doesn't have direct evidence of the murdering cartel's motives is, quote, not surprising, as persecutors are hardly likely to provide their victims with affidavits, end quote. In any event, it's not overly important why the uncles were killed. What's important here is whether there's a 10% chance that Mr. Hermosillo will be killed because of his relationship to his uncles. Want a really specific standard? I do. Quote, Mr. Hermosillo's evidence is exactly what one might expect at the screening stage. A credible account that cartels target relatives of autodefensa members, supported by testimonial evidence and backed by the representation that additional evidence exists to support his assertions, end quote. Make your reasonable fear interview case like this one. Similar rationale for sending it back on cat protection and police acquiescence in Mexico, too. This is only the reasonable fear stage, reiterated the court. Judge Bennett dissented, relying largely on standards of review. But, congratulations Zulu Ali for petitioner. And that is Hermosillo v. Garland. Next up is Rudnitskyy v. Garland, published by the Ninth Circuit on September 14th, 2023. This case is directly about the stop time rule for LPR cancellation of removal, a rule we're going to get into again this episode, although a bit tangentially there. The holding in this case is that, quote, the stop time rule is calculated from the date the petitioner committed a criminal offense that rendered him removable, rather than the date he was convicted, end quote. If I'm being honest, I thought that was pretty settled. Guess not. Mr. Rudnitskyy is a lawful permanent resident from Ukraine who entered as a refugee in 2003. He got a not insignificant criminal history, though, including a possession of heroin conviction. When placed in removal proceedings, he applied for LPR cancellation of removal under I&N Section 240A. That relief requires that the LPR have not been convicted of an aggravated felony. It also, however, requires that the LPR have held LPR status for at least 5 years, and have held any lawful status, which can include the LPR status, for at least 7 years. Those 7 years, though, stop as a matter of law even if not as a matter of fact, of course, because no one can stop time. Quote, when the non-citizen is served with an NTA, or when the non-citizen has committed an offense referred to in I&N Section 212A2 that renders the non-citizen inadmissible under Section 212A2, or removable from the United States under Section 237A2 or Section 237A4, end quote. The notice to appear stop time rule is what we're always talking about with the Pereira and Chavez line of cases. Deficient NTAs don't implicate the stop time rule anymore. This case is about the other way to stop time. Mr. Rudnitsky's actual possession of heroin occurred just a few months before he got his 7 years. The conviction occurred after the 7 years. And a conviction for possessing heroin will make a non-citizen inadmissible under I&N Section 212A2. Issue teed up. Now, Mr. Rudnitskyy was removable, but he wanted LPR cancellation. After a very complicated and drawn-out procedural history, the IJ ultimately concluded that commission of the heroin offense stopped the time, making him ineligible for LPR cancellation. He didn't have the 7 years. The IJ also denied asylum and related relief pre-Russia's invasion of Ukraine. The BIA affirmed. In a nutshell, Mr. Rudnitskyy argued that because LPRs don't become removable unless and until they get a conviction, the mere commission of an offense can't implicate the stop time rule. They aren't, quote, rendered removable, end quote, as the stop time rule seems to require, until there's a conviction. The stuff about committing an offense that makes a non-citizen inadmissible in the stop time rule is not applicable to LPRs, so the argument goes, unless I suppose they depart the United States and seek re-entry, and so need to tangle with the inadmissibility provisions of Section 212, then. The huge problem for Mr. Rudnitskyy is that the Supreme Court rejected this argument in Barton v. Barr, podcast episode 1, Jar Jar Binks and everything. And in fairness to Mr. Rudnitskyy, Barton wasn't published when much of this case was being litigated. Before the Ninth Circuit, Mr. Rudnitskyy tried to distinguish Barton, but that's unlikely to succeed when the Supreme Court has ruled pretty much on the exact issue against you. Now true, Mr. Rudnitskyy made different arguments than the non-citizen did in Barton, but they were pretty similar, and more importantly, the Supreme Court all but directly rejected the arguments already. In so doing, by the way, the Supreme Court expressly overturned Ninth Circuit precedent, the Nguyen decision. Possibly why this panel is now publishing this decision, to make it clear what the new rule is in the Ninth Circuit post-Barton. I don't know, to me, after Barton, the rationale for all the logic and stuff isn't all that important. The rule is that, quote, the date of commission is the relevant date for computing when the stop time rule applies after a conviction has rendered a non-citizen removable, end quote. It didn't matter to the Supreme Court there that LPRs can't be removed based on inadmissibility provisions because the statute at issue, the stop time rule, isn't about removability. It references inadmissibility. It's not about inadmissibility or removability, said the Supreme Court. It simply describes the event, commission of certain crimes, that stop the continuous physical presence clock. Nor does it matter, said the Supreme Court and now Ninth Circuit, whether the conviction that makes the LPR removable is the same offense, commission of which is stopping the clock for continuous physical presence. Still need to have a conviction or admission to conduct within the meaning of matter of K to satisfy the stop time rule, don't get me wrong. But if you have that, the commission of the crime at issue need not be the same conviction that is making the LPR removable. The panel explained that other than the Ninth Circuit's Nguyen decision, now overturned by Barton, the BIA and all other circuits to have considered the issue have issued holdings similar to the one that the Ninth Circuit is now adopting. The Ninth Circuit joins them. Mr. Rudnitskyy therefore lost his case. Very complicated, but also Supreme Court precedent almost directly on point. And while the Ninth Circuit denied his stay request as moot because it has now denied his petition for review, I'm pretty sure we're not removing people to Ukraine at the moment. I don't know. Change country condition motion to reopen to come? Who knows? And that is Rudnitskyy v. Garland. Next, you knew it was coming. Matter of Cabrera-Fernandez, published by the BIA. The BIA has finally ruled on the parole issue. in a manner generally adverse to non-citizens. I can only imagine a petition for review will be coming soon. Don't get me wrong, it's not the most surprising ruling in the world. Essentially, the non-citizen bar was asking the BIA to kind of reconsider its prior positions in light of recent Supreme Court precedent that was not directly addressing the issue. The BIA declined to do so, and in so doing declined to help tens of thousands of non-citizens. But the issue is huge. What is a parole? Parole is uber important under immigration law because to adjust status based on, say, a marriage to a U.S. citizen, a non-citizen now must be inspected and admitted or paroled into the United States first. They can't do so if they've entered unlawfully. Or, like in the case of Mr. Cabrera-Fernandez, the Cubans. There are lots of Cuban LPRs or U.S. citizens of Cuban descent who were once Cuban LPRs. One of the reasons for all these Cuban LPRs is because it is much easier for a Cuban to become an LPR than pretty much any other non-citizen. Cubans don't need a qualifying relative or a sponsoring employer. They don't need to suffer persecution or trafficking or be the victim of a crime, nothing like that. Under the Cuban Adjustment Act, all a Cuban must do is get to the United States, not commit a disqualifying crime or other conduct, and wait a year. Provided, that is, that they have been inspected and admitted or paroled into the United States. Due to the wet foot, dry foot policy for decades, immigration authorities would essentially parole in all Cubans who made it to land, meaning that they could become LPRs after a year. No more. It ended under the Obama administration, and neither the Trump nor Biden administrations have re-implemented wet foot, dry foot. Meaning that the Cubans are now in a position similar to all other non-citizens. If they enter the U.S. without authorization, they don't have a direct path to adjusting to LPR status, because they haven't been paroled in, as the Cuban Adjustment Act, and for that matter, I&N Section 240A, requires. Or have they? That's the issue here. Mr. Cabrera-Fernandez is Cuban, was apprehended 40 minutes after entering the United States, and was detained for a few days. DHS then released him on his own, quote, recognizance pursuant to DHS's conditional parole authority under I&A Section 236A2B, end quote. So says the BIA. As so framed, that used to clearly mean pretty much nothing. It wasn't a parole. The IJ, however, concluded that what DHS had actually done was release Mr. Cabrera-Fernandez, quote, pursuant to a grant of humanitarian parole under I&A Section 212D5A, end quote. And that is totally a parole for Cuban Adjustment Act and I&A Section 245A purposes. If you get it, you could adjust. If you have the other qualifications, of course. DHS has pretty much unfettered discretion to parole non-citizens into the United States for humanitarian purposes. So why wasn't this what DHS had done? And it has huge implications. And again, for Mr. Cabrera-Fernandez, that meant that he could adjust to LPR status under the Cuban Adjustment Act after a year. It's a very big deal, as all those Cubans before him know. The IJ so held based on statements and logic made by the Supreme Court in Jennings v. Rodriguez a few years ago. And hey, Supreme Court dicta is very powerful stuff. See, the IJ believed, correctly, that when apprehended, Mr. Cabrera-Fernandez was subject to expedited removal under I&A Section 235B1. Removal without even going before an immigration judge. In Jennings, the Supreme Court, quote, describes Section 212D5A parole as the sole mechanism authorizing the release of individuals detained for expedited removal, end quote. Ipso facto, if, as occurred, Mr. Cabrera-Fernandez was released, he must have been released via humanitarian parole. While Mark Prada and Anthony Dominguez aren't listed on this decision, they've been at the tip of this spear for a while, and have made other arguments that, quite frankly, appear unaddressed in this decision. Anyway, the BIA disagreed with the immigration judge and said that this was not a 212D5A parole. Mr. Cabrera-Fernandez, and actually his co-respondents in this matter, were deemed applicants for admission by DHS when they arrived. Unsure if that would have been the case in the Ninth Circuit, though, because they were physically inside the United States when they are apprehended, but whatever, they were here in the 11th Circuit. They're applicants for admission. As applicants for admission, the BIA explained, DHS has the authority to institute expedited removal proceedings, or full-fledged removal proceedings before an IJ. It's up to them. Here, it appears that DHS did the latter, Naturally, right? Because Mr. Cabrera-Fernandez did end up before an immigration judge. Now, the record doesn't show that DHS went through all the motions and procedures that usually follow a grant of humanitarian parole. Rather, what they did, explained the BIA, was a grant of conditional parole, the kind of thing that apparently happens in all other cases when DHS releases non-citizens from immigration detention without specifically citing to INA Section 212d5. I don't know, I'm kind of reading the tea leaves here. It was a pretty short decision, and the BIA doesn't quite explain how we will know whether or not what DHS is doing is actually a 212d5 humanitarian parole. But if it's a conditional parole, explained the BIA has long held that a conditional parole is not a parole within the meaning of the Cuban Adjustment Act or INA Section 245A. What about Jennings, though? Well, that case held that, quote, detained individuals in expedited removal proceedings are not entitled to bond hearings under the terms of the statute irrespective of detention length, end quote. So that's obviously not the direct question at issue here. But what about Jennings and all of that dicta? To be honest, and a bit disappointingly, the BIA doesn't really explain much else on this point. Perhaps the BIA knows that the matter is going to the circuits eventually and that the circuits are equally capable of interpreting Supreme Court precedent. Still too bad, though. Nor is this case, explained the BIA, like the BIA's 1977 decision in matter of O, where military evacuees from Vietnam were deemed to have been 212d5 paroled, despite no citation to that statute. In that case, matter of O, explained the BIA, the individuals were in the old exclusion proceedings, and there was no other possible legal way that they could have made it into the United States. But now, exclusion proceedings are no more, everything is removal proceedings, and INA Section 236A2B, quote, provides DHS with an alternative statutory mechanism for releasing the present respondents, which was followed in this case, end quote, apparently. Here, quote, DHS did not release them under the terms required to invoke the humanitarian parole, end quote. Again, unclear what those terms actually are, but Section 212d5 certainly wasn't cited. The immigration judge out of Miami was therefore overturned, and neither Mr. Cabrera-Fernandez nor thousands like him can adjust to LPR status. The BIA has set the Avila, South Florida community on fire. Round 1 concluded. And that is matter of Cabrera-Fernandez. Next up, Peguero, Vasquez v. Garland, published by the Second Circuit on September 13th, 2023. This decision is about crimes involving moral turpitude and much more. Judge Robinson dissented. Mr. Peguero Vasquez is from the Dominican Republic and was admitted to the United States as a lawful permanent resident in 2012. But in 2017, he was convicted of possession of a forged instrument under New York Penal Law Section 170.20, which is a Class A misdemeanor under New York law. Apparently, he was using a fraudulent license plate. Then he got convicted of possessing heroin. DHS initiated removal proceedings. In addition to the heroin stuff, DHS alleged that the license plate thing was both an aggravated felony and a CIMT committed within 5 years of Mr. Peguero Vasquez entering the United States as an LPR. All of that would make him removable for a few reasons, but the BIA only ended up affirming the CIMT ground, the CIMT within 5 years. So that's what's before the Second Circuit. The thing is, though, like what happened in California, and at least in part for expressly immigration reasons, quote, in 2019, after his conviction, New York enacted Penal Law Section 70.15(1-A), which lowered the maximum possible sentence for Class A misdemeanors from 1 year to 364 days, end quote. And that New York law is expressly retroactive, meaning that Mr. Peguero Vasquez's conviction no longer entails a sentence of at least 1 year. And that means that he wouldn't be removable for having been convicted of a CIMT because INA Section 237A2AIII requires that the offense entail a potential sentence of imprisonment of at least 1 year. His New York license plate thing offense no longer does, which of course is one of the main reasons New York passed the law that they did in the first place. for people like Mr. Peguero Vasquez. If his conviction had happened today, that would clearly have been the case. But remember, his conviction occurred before the New York change in law. At that time, Class A misdemeanors in New York brought with them a potential sentence of at least 1 year, meaning that they and Mr. Peguero Vasquez's conviction were not, in 2017, accepted from I&A Section 237A2AI. Mr. Peguero Vasquez argued before the IJ that as New York expressly intended, the change to the possible sentence making it only 364 days applies retroactively, and so the IJ should recognize the retroactive application and find that his conviction in 2017 did not actually entail a potential sentence to a term of imprisonment of at least 1 year, again, making him not removable for the CIMT ground. Even though it technically did in 2017. Lots of time traveling in this episode. Confused yet? Mr. Peguero Vasquez also argued that the elements of his offense didn't meet the definition of a CIMT. The IJ and the BIA rejected all of these arguments. The Second Circuit affirmed by split decision. Like the Ninth Circuit did in 2020 on California's similar law, California Penal Code Section 18.5a. And like the BIA did with that California law in the decision underlying the Ninth Circuit's decision in matter of Velazquez-Rios. So, we all agree that it's federal law, rather than state law, that generally controls these things. And the INA has its own definition of conviction that's not entirely dependent on state definitions of conviction, creating a very complicated and dangerous situation for practitioners. Generally, when we're talking crimmigration, the elements and other legal requirements of the statute of conviction are judged by the state requirement for that crime at the time of conviction, and are then compared against the definition of the federal offense at the time of removal proceedings. So in practice here, the 2017 elements of the New York offense compared to, say, the 2019 or 2020, whenever removal proceedings were happening, elements of a CIMT, and definition of an immigration conviction. So that's bad for Mr. Peguero Vasquez. But even worse for him and his arguments, the Supreme Court apparently rejected a similar argument with different statutes in the Armed Career Criminal Act context in 2011. When the sentence is what's at issue, explained the Supreme Court in McNeil v. United States, the court should consider, quote, the law under which the defendant was convicted, rather than the law in effect at the time of federal sentencing, end quote. Pretty rough quote for the argument, and one relied upon by the BIA in matter of Velazquez-Rios. It was of no importance to the BIA here that New York expressly made its new term of imprisonment law retroactive, and again the Second Circuit agreed. Because to the court, quote, there is no doubt that the federal removal statute is backward-looking, end quote. Although I&A Section 237A2AIII refers to a situation where a sentence of 1 year or more may be imposed, a present tense phrase, the focus to the Second Circuit is what might have been imposed at the time of conviction, to the, quote, historical fact of a non-citizen's conviction, end quote. After all, reasoned the court, what would happen if, say, some other state, quote, stiffened penalties, end quote, to make non-citizens removable after the fact? That highlights the problem of not focusing on the law at the time of conviction, explained the Second Circuit. None of this violates principles of federalism, explained the majority. On the other hand, though, people with convictions like Mr. Peguero Vasquez will not be removable going forward post-2019 change of law. That's how federalism comes into play to help the non-citizen. But not Mr. Peguero Vasquez. Seems like he may have abandoned his arguments that the offense itself didn't match the definition of a CIMT? Unclear. Because the last thing the Second Circuit addressed was simply Mr. Peguero Vasquez's argument that the CIMT definition is itself unconstitutionally vague. That old argument. The Second Circuit believed itself bound on this issue by very old Supreme Court precedent. I doubt any circuit will bite on this. Probably up to the Supreme Court to overturn Jordan v. DeGeorge, should it so desire. But hey, it's got to get to the Supreme Court somehow. Let's keep trying, y'all. And there are certainly a bunch of circuit judges who believe it should be overturned. So there's that. Judge Robinson may or may not be one of those judges. I'm not sure. Judge Robinson dissented and would hold that due to New York's expressly retroactive change, quote, the version of state law that he was actually convicted of violating, end quote, did indeed only include a potential term of imprisonment of 364 days. Judge Robinson would rule for Mr. Peguero Vasquez. Judge Robinson pretty much wrote the opposite decision as the majority, addressing most if not all of the majority's arguments. So I encourage you to read the dissent, if and when you come across this issue somewhere that's not the Second or Ninth Circuits. And a bit more caught my eye too. Before I checked my notes, I had written in my outline that the Ninth Circuit's Velazquez-Rios decision on this issue in California had occurred last year. My notes reflect, however, that it was actually nearly 3 years ago, 150 episodes ago on episode 27. I cannot believe that. I am losing my mind. This is episode 177. What a ride it's been. Not stopping either. And here's a quote that comes to mind as federal judges in Texas ponder DACA and Governor Abbott's floating wall of saws. Quote, whatever understandable frustrations a state may have with immigration policy, it may not pursue policies that undermine federal law. End quote. And that is Peguero Vasquez v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. Moving on to Avila v. Attorney General of the United States, published by the Third Circuit on September 14th, 2023. This case is about convictions. Miss Avila is from Honduras. Her life there was, quote, punctuated by sexual violence, end quote. Raped at knife point at 7 years old. It goes on for years and years, and it's really just horrible stuff. Not going to really get into it. It had horrible psychological effects on her. She fled Honduras in 2001 and somehow became a lawful permanent resident. But she got quite a few convictions, and when she left and tried to come back in as an LPR at some point after that, DHS took the position that one of her convictions was a CIMT, making her an applicant for admission, meaning that she couldn't keep her green card, and so DHS put her in removal proceedings to find out. Could have detained her too, without the opportunity for bond from an IJ, if I'm not mistaken. All simply because she left the US and tried to come back in. Terrifying framework. She was not detained, it seems. She didn't show up for her hearing and was ordered removed in absentia. But those proceedings were eventually reopened. Well done, someone. And Miss Avila moved to terminate her case, claiming that the conviction alleged was not, in fact, a CIMT. So she wasn't an applicant for admission. So she should be permitted to just enter the US and keep her green card. Or that is to say, she conceded that one of her crimes was a CIMT, but that it met the petty offense exception at INA section 212A2A Unfortunately, the petty offense exception requires, among other things, that CIMT be the non-citizen's only crime. Miss Avila argued that her other offenses were not actually crimes, though. They were merely disorderly persons offenses, and not crimes, under the Third Circuit's decision in Castillo v. Attorney General of the U.S., a Third Circuit decision that we'll discuss in a bit. The IJ disagreed and denied everything, including LPR cancellation of removal. The IJ found that she did have a CIMT that didn't meet the petty offense exception. And while CIMTs don't per se bar LPR cancellation of removal under INA section 240AA like they would of non-LPR cancellation of removal, Their commission does stop the accrual of the 7 years continuous physical presence in any status required of LPR cancellation, as we just discussed. And that's what happened here. She didn't have her 7 years because of the commission of her CIMT offense. The IJ also denied asylum and related relief. The BIA affirmed. In so doing, the IJ relied on the now overruled matter of ABs. ABI? Now, the BIA did recognize that matter of AB had been vacated by Attorney General Garland by the time it got up to the BIA, but the BIA still denied based on older precedent. Quite the case before the Third Circuit with many issues, as all of the decisions seem to be this week. First, and notwithstanding some complicated and clever arguments, the Third Circuit agreed that Miss Avila was properly charged as an arriving alien, that her disorderly persons stuff were actually crimes, and that at least one of those crimes was a CIMT, commission of which stopped her from accruing continuous physical presence for LPR cancellation of removal purposes. Because here Miss Avila had a problem. Because during the pendency of her case, the BIA published matter of S. Wong, which held that New Jersey disorderly persons offenses are indeed crimes under the INA's fun definition of a conviction at INA section 101A48, episode 101. So Miss Avila's got to deal directly with matter of S. Wong. Under administrative law, and unless the Supreme Court vacates Chevron deference next term, the Third Circuit must defer to matter of S. Wong unless the Third Circuit believes the immigration statute itself clear, or the BIA's decision unreasonable. It didn't believe either the case. Because INA section 101A48, the definition of a conviction, is very confusing, and many circuits, including the Third Circuit, have previously deemed it ambiguous as to just what is required to make a state court action a conviction under immigration law. Read the statute and you might agree. With the immigration statute itself deemed ambiguous, Miss Avila only wins if the Third Circuit believes matter of S. Wong unreasonable. The Third Circuit did not believe matter of S. Wong unreasonable. And if it wasn't already, it's about to get confusing. INA section 101A48 requires, among other things, that to be a conviction, the state offense must be a, quote, judgment of guilt, end quote. In the 2004 decision, matter of Eslamazar, the BIA held that that means judgment in a criminal proceeding, and nothing less, as lesser proceedings wouldn't require proof beyond a reasonable doubt. Okay. But then in Castillo, the Third Circuit said that even that's not quite right. Even if the state proceedings require that each element be satisfied beyond a reasonable doubt, whether a criminal or a criminal-like proceeding will constitute an immigration conviction requires a, quote, open-ended inquiry that considers how the prosecuting jurisdiction characterized the offense at issue, the consequences of a finding of guilt, and the rights available to the accused, as well as any other characteristics of the proceeding itself, end quote. Even if deemed criminal by a state, is it really criminal? The Third Circuit wants IJs to investigate. At least it did, until matter of S. Wong, episode 101. And, quote, Wong instructs that the critical inquiry in determining the substance of the proceeding is whether it requires minimum constitutional safeguards, end quote. From matter of S. Wong, quote, such constitutional protections include proof beyond a reasonable doubt, the right to confront one's accuser, a speedy and public trial, notice of the accusations, compulsory process for obtaining witnesses in one's favor, and against being put in jeopardy twice for the same offense. The absence of these protections renders the proceeding non-criminal for federal purposes, end quote. Although not always, the BIA kind of left an ambiguous exception. But anyway, that's the matter of S. Wong's standard. And in this decision, the Third Circuit agreed that not only was that standard reasonable, but its prior precedent is no longer good law, and New Jersey disorderly persons offenses meet the standard, as the BIA also held in matter of S. Wong. Even though the BIA clearly changed its position in matter of S. Wong from matter of Eslamazar, it explained why that was, and not least of which because a circuit split developed over Eslamazar. Looks like Castillo is no more in the Third Circuit. Rough. So Miss Avila's disorderly person offenses are crimes, meaning that because her other conviction matches the elements of a CIMT, She cannot benefit from the petty offense exception because that CIMT is not her only conviction. If you're still following, Miss Avila still had her asylum claim to adjudicate. And on this, the Third Circuit explained, it's going back. Because fortunately for Miss Avila and as today, matter of ARCG was good law at the time the BIA ruled. That decision, ARCG, found the particular social group of, quote, married women in Guatemala who are unable to leave their relationship, end quote, cognizable under immigration law. Jeff Sessions hates it. Still requires a factual inquiry into how a country treats the group and that group's characteristics. But the group and ones like it can be a basis for asylum. Here, in contrast, the BIA did not at all, quote, examine Miss Avila's particular social group within the context of the specific country conditions in Honduras, end quote. The BIA just kind of seemed to believe that the group of, quote, Honduran women in a domestic relationship where the male believes that women are to live under male domination, end quote, covers too many people. But that's not a sufficient analysis, particularly where there is, quote, evidence in the record that less than 1 in 5 cases of femicide are investigated, and that the average rate of impunity for sexual violence and femicide is approximately 95%, end quote, in Honduras. Pretty similar group to the one in ARCG, too. So the Third Circuit sent it back. And it seems like the Third Circuit is asking the BIA or Attorney General Garland to finally provide some dang guidance on this important issue. Let's go, Attorney General! As the prior administration showed, this is a completely proper area for Attorneys General to issue multiple decisions on. Big case. And while it's not the full win you wanted, congratulations Kaylee J. Miller-Schaefer and Theodore J. Murphy for petitioner. Thinking out loud. If Miss Avila is charged as an applicant for admission, and she was only removable because she has CIMTs, why can't Miss Avila apply for a standalone INA Section 212H waiver, as she was trying to re-enter with her green card? Does she not have a qualifying relative? The decision briefly mentions that the IJ denied 212H relief, but why? Do her convictions make her that bad of a person that the relief was denied as a matter of discretion? Particularly considering her childhood of familial gang rape, beatings to the point of miscarriages, and domestic violence leading to attempted suicides? Interesting, these cases. Undiscussed, and of course I don't have the full record, not even close. But I'm curious. And that is Avila v. Attorney General of the United States. Next, Muñoz de Zelaya v. Garland, published by the Fifth Circuit on September 12, 2023. If you're looking for a break from the long, heady crimmigration ones, here's your case. This is a gang-based asylum decision, and it's not great for asylum seekers. The petitioners are Miss Muñoz de Zelaya and her husband and their 2 minor children, all from El Salvador. Miss Muñoz de Zelaya is the lead asylum applicant with her family listed as derivatives, so if she wins, they do too. The family owned a business in El Salvador. Miss Muñoz de Zelaya's husband was extorted by gangs. A gang member put a gun to his head and threatened to murder him if he didn't pay. The husband fled to the United States instead. Miss Muñoz de Zelaya remained behind for a little bit, but fled towns with the kids. But then the extortion began against her, and when she couldn't pay, the gang threatened to initiate her son into the gang and take her children and torture them. She too had a gun pointed at her head and threatened. Gangs ransacked the home and beat Miss Muñoz de Zelaya unconscious. The gang members threatened to kill a neighbor who had witnessed everything. Miss Muñoz de Zelaya fled with her children the next day. The IJ denied everything. The IJ believed Miss Muñoz de Zelaya and the family, but didn't believe that the terrible harm had occurred on account of them being members of the particular social group of, quote, extorted business owners, end quote. Or that is to say, the IJ didn't believe that particular social group cognizable under immigration law. Either way, a no nexus finding. Plus, the IJ thought that Miss Muñoz de Zelaya and the family could relocate in El Salvador. I guess a second time? The BIA affirmed on the no nexus finding. The Fifth Circuit here agreed that the purported particular social group of, quote, Salvadoran business owners, end quote, is not a valid particular social group. Might have more luck in other circuits, though, based on recent precedent, if I'm remembering. The term business owners is not an immutable trait, as the Fifth Circuit has apparently recognized on previous occasions. That's a holding that I believe one or two circuits have expressly disagreed with recently, as reflected on the podcast social media page, as well as the list of cases. A particular social group must be immutable, particular and socially distinct in the society in question. And this group didn't even pass that first hurdle, said the Fifth Circuit. It's not immutable. Being a business owner is not something that a non-citizen cannot change or shouldn't be expected to change. Pulling out all the stops, Ms. Munoz de Zelaya pivoted before the Fifth Circuit and asserted that her family membership is a valid particular social group, and that that's at least one central reason for why she was harmed. Seems like it might have been. Problem is with the Fifth Circuit is that she didn't make that argument below. Possibly because, at least at the time of the removal proceedings before the immigration judge, Attorney General Barr was casting serious shade on family-type asylum claims. I don't know. But anyway, while the Fifth Circuit can waive this failure to exhaust following the Supreme Court's Santos-Zachariah decision this term, and maybe should based on the whole law being in flux thing, the Fifth Circuit declined to do so. Also, some citations in this decision that the panel might intend to be used later as a basis in the future to find that the claims processing rule of exhaustion will be deemed mandatory and I guess unwaivable in the Fifth Circuit? Unclear, stay tuned. The implications of Santos-Zachariah on circuit practice are just getting started. Nor was the Fifth Circuit biting on Ms. Munoz de Zelaya's alternative argument that actually the agency lacked authority to deny asylum in the first place because the NTAs were deficient, an argument that the court noted was not exhausted below. Ms. Munoz de Zelaya and her family, therefore, lost their case. And that is Munoz de Zelaya v. Garland. And so back to crimmigration we arrive. This is Solis Flores v. Garland, published by the Fourth Circuit on September 11th, 2023. Mr. Solis Flores is from Mexico. He's been in the United States a long time and has U.S. citizen immediate family, and so, when placed in removal proceedings, he applied for non-LPR cancellation of removal under I&A Section 240A-B. But he has a conviction from 2000 for receiving stolen property in violation of Virginia Code Section 18.2-108. An IJ determined that the conviction was a crime involving moral turpitude, which therefore categorically barred Mr. Solis Flores from non-LPR cancellation. The IJ granted Mr. Solis Flores post-conclusion voluntary departure, though, under I&A Section 240B-B. No removal order, but still surely a 10-year bar once he leaves due to his unlawful presence in the United States. The BIA agreed that the conviction was a CIMT, but the BIA, quote, declined to reinstate voluntary departure or remand to the IJ for that purpose, because Mr. Solis Flores had not posted the required bond despite receiving proper notice of his obligation to do so, end quote. Gonna get to that issue in a minute. And one BIA member dissented on this latter point. Lots of split decisions, it seems, recently from the BIA, no? To the Fourth Circuit it all went. And the Fourth Circuit first agreed that receiving stolen property in violation of Virginia Code Section 18.2-108 is a CIMT. Bit of a favorable quote in the first line with recent CIMT precedent like Zarate out of the 11th Circuit and Walcott out of the 9th Circuit, though. Quote, a crime involving moral turpitude is one that not only violates a statute, but also is inherently immoral, end quote. I can live with that. Receiving stolen property in Virginia is, though, said the Fourth Circuit. First, the BIA has long held that receiving stolen property is a CIMT. And for purposes of the amorphous CIMT standard when it comes to receipt of stolen property offenses, what matters is, quote, the defendant's knowledge of the stolen nature of the property, end quote. If the statute of conviction requires such knowledge by the defendant, the crime is likely a CIMT, according to the BIA and now the Fourth Circuit. This is in contrast to theft and larceny type crimes, where the important mens rea for CIMT purposes is whether the statute requires an intent to permanently deprive the owner of the property. putting aside the BIA's attempt in 2016 to change this standard. Mr. Solis-Flores argued, essentially, that receipt of stolen property type offenses should include this mens rea required for theft offenses to be CIMTs, the intent to permanently deprive. Mr. Solis-Flores argued by relying on very old BIA decisions, and there's nothing wrong with that. The Fourth Circuit just reads those decisions a bit differently than does Mr. Solis-Flores. Alright, fine. The Virginia receipt of stolen property has the requisite intent to make it a CIMT because it requires the defendant's knowledge of the stolen nature of the property. But is that inherently immoral? Yes. Quote, "It is morally wrong to possess property knowing it has been stolen from its rightful owner," end quote. And apparently, the vast majority of other circuits agree that receiving stolen property is a CIMT. Only the Ninth Circuit apparently has held otherwise in Castillo-Cruz v. Holder, published in 2009, a decision that the Fourth Circuit here believes was, quote, "based on an incorrect assessment of BIA precedent," end quote. According to the Fourth Circuit, and contrary to what the Ninth Circuit had found, the BIA has not truly ever required theft of stolen property offenses to require an intent to permanently deprive in order to make them morally turpitudinous. Again, knowledge that the property is stolen is probably sufficient. So again, having set out the standard, the Fourth Circuit believed that the Virginia crime here meets it. It requires, for example, the knowledge that the goods were stolen and dishonest intent. Awesome argument by Mr. Solis-Flores among many, though. Mr. Solis-Flores found a case where, indeed, it appears the individual was convicted without a showing of this intent. Mr. Solis-Flores satisfied the realistic probability test, meaning that his conviction shouldn't be a CIMT, because Virginia prosecutes offenses that don't require knowledge that the goods were stolen, for example. The problem is that the Virginia Supreme Court then overturned that conviction for the reason, that is, the defendant didn't have the requisite intent. So that's not the law in Virginia. The law in Virginia aligns with the Fourth Circuit's definition of a CIMT. But still, argued Mr. Solis-Flores, in between the lower court's ruling and the Virginia Supreme Court ruling, someone could be convicted in an overbroad manner in Virginia. We know of at least one, this decision that was then decided by the Virginia Supreme Court. And all of this happened many years after Mr. Solis-Flores' conviction in 2000, meaning that technically, he could have been convicted in an overbroad manner in 2000. What an argument. Restated, Virginia appears to have been applying the statute overbroad as of the date of Mr. Solis-Flores' conviction in 2000. It certainly did at one time in 2008, eventually overturned by the Virginia Supreme Court. To the Fourth Circuit, though, Mr. Solis-Flores failed to identify any other case where the Virginia courts so applied the statute overbroad. He certainly didn't point to his own case. So, as the Virginia Supreme Court has now clarified things, the Fourth Circuit held that Mr. Solis-Flores hadn't actually established a realistic probability that the statute would be applied overbroad. I don't know, though. Heck of an argument. Still going back, though, even though Mr. Solis-Flores lost on the CIMT issue, because of voluntary departure. I told you, all the cases this week have like 4 holdings. After Mr. Solis-Flores received voluntary departure from the immigration judge, he did not pay the mandatory bond required of people who get voluntary departure. That usually means that the VD grant expires, and would mean that the BIA was right here not to reissue voluntary departure. But Mr. Solis-Flores argued that actually, the IJ didn't comply with the voluntary departure regulation at 8 CFR section 1240.26 C3I. That statute, quote, requires the IJ to inform a non-citizen of the bond obligation before granting voluntary departure, end quote. Contrary to the regulation, as occurred here and as often occurs, the IJ didn't inform Mr. Solis-Flores of his actual bond obligation until after the IJ granted voluntary departure. One member of the BIA, again, would have granted the appeal in part for this regulatory violation and sent it back for further consideration of voluntary departure. The Fourth Circuit agreed with this dissenting member. And I mean, the regulation is pretty clear. Quote, before granting voluntary departure, the immigration judge shall advise the non-citizen of the specific amount of the bond to be set and the duty to post the bond. End quote. Minimum bond is $500, by the way. Looks like IJs need to change up how they do voluntary departure now, because in the Fourth Circuit, quote, it was insufficient for the IJ to advise Mr. Solis Flores of the bond amount and deadline in the order itself, end quote. So actually, it's going all the way back to the IJ, quote, for a new period of voluntary departure with the required advisals, end quote. Therefore, and while you didn't get everything you wanted, congratulations Ben Winograd and Lisa T. Johnson Firth for petitioner. And because I rarely miss the opportunity, citation in this decision aside, in what is dicta anyway for purposes of the question presented? I am unaware of any circuit having yet deferred to the BIA's new definition of a theft-type CIMT from 2016 in matter of Diaz-Lizarraga. In that decision, the BIA redefined the CIMT definition for theft-type offenses and said that state crimes need not necessarily require an intent to permanently deprive to be a theft-type CIMT. Again, the issue in this Fourth Circuit decision here regarded receipt of stolen property offenses, not theft-type CIMTs. I may be misremembering, but I don't think any circuit has deferred to matter of Diaz-Lizarraga. This decision certainly is not. Just thought I'd mention. And that is Solis Flores v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.